Okay, let's just dive right into this. Welcome to this superpowered explainer where we're going to take those overwhelming contract prompts and literally transform them into perfectly structured essays. And we'll do it using just a little bit of friendly detective work. So, if you've ever felt completely lost staring down a massive fact pattern, you are in exactly the right place.
Because, look, here's the harsh reality of being a law student. You spend weeks, maybe even months, memorizing this incredibly dense, exhaustive course outline. You know the rules. But there is this scary, very real gap between memorizing that massive outline and sitting there, staring at a blank exam page, trying to figure out where to even begin. You know the law, but how do you actually write a contracts essay that gets top marks? That's what we're solving today.
To get there, here's our quick roadmap. First, we'll look at the challenge itself. Second, our core methodology. Third, we'll get into reverse engineering. Fourth, we'll break down the facts. And finally, we'll cover structuring your analysis.
Starting off with Section 1, the challenge, which is usually outline overload.
Now, what's really terrifying is looking at an exhaustive list like this. This represents a massive contracts I and II course outline. You've got everything from intent to contract to the Uniform Commercial Code, all the way down to breach, remedies, and third-party issues. It is completely natural to wonder how on earth you'll ever fit all these rules into a single essay. But here's a spoiler alert, you absolutely don't have to, and honestly, you shouldn't even try.
So let's move to Section 2, core skills and methodology. Obviously, your substantive knowledge is essential, but you simply cannot successfully do your issue spotting if you fail to read properly. So we rely on a brilliant three-step reading strategy. Read the facts, read the call of the question, and then read them both again. Understanding the call to the question provides the crucial context you need for the facts. Doing this right up front lets you choose the initial reading order that best fits your unique cognitive style.
And this brings us to the golden rule of this entire explainer: fact anchoring. The crucial point here is that you must anchor every single piece of law directly to a specific fact in the story. You only discuss issues that have explicit factual triggers in the prompt. If you just start dumping rules from your outline that have no factual support whatsoever in the prompt, you're going to yield absolutely zero credit. Fact anchoring has to be your compass.
All right, Section 3, reverse engineering the prompt. Let's look at a classic law school mess. Meet Anne. She wants to buy her boyfriend, Ben, a gift. They head over to Ritz Jewelry, where Ben picks out a $2,400 solid 8-karat gold chain. Anne buys it on a written installment plan, and that plan explicitly says the contract is not assignable. Fast forward, Anne and Ben break up. But Anne says Ben can go ahead and keep the chain. Ben takes it to get cleaned and, plot twist, discovers it's not solid gold at all. It's just cheap gold plating, and it's wearing off. So Ben decides to sue Ritz directly. Meanwhile, Ritz had already assigned Anne's payments to Credit Co. Anne finds out the chain is fake and flat out stops paying Credit Co. Like I said, a total mess.
But this perfectly illustrates exactly how we handle things using essay reverse engineering. By deeply understanding the call to the question, which you see on the left, we don't panic. Instead, we instantly flip those daunting prompts into a beautifully structured, bite-sized issue checklist on the right. For question 1, Ben versus Ritz, we break it down into applicable law, Ben standing, contract formation, and breach. For question 2, we look at whether the right was assignable and the effect of that anti-assignment clause. And for question 3, Credit Co versus Anne, we look at Credit Co standing to sue and Anne's failure to pay as a breach.
Which leads us perfectly into Section 4, breaking down the facts.
Let's look at the actual words used in the prompt. Anne explained to Charles that she wanted to purchase a gift for Ben. And then later on, Anne made it clear that Ben could keep the gold chain. The prompt doesn't just casually toss Ben's name in there. It explicitly tells us right from the start that the item was intended as a gift for him.
Now notice how we physically tie the text together here. The fact trigger, that both Anne and Ritz intended this as a gift for Ben during contract formation, connects directly to the legal concept of Ben qualifying as an intended third-party beneficiary. This is fact anchoring and issue spotting in action. We aren't just discussing third-party rights because they happen to be on our outline. We're discussing them because the facts practically shouted us to do so. And because of this highly specific fact, his property rights remain completely intact even after the relationship with Anne ended.
Next, let's look at the product itself. The prompt states the contract identified the chain as solid 18K gold, but later, Ben discovered that the chain was not solid gold after all, but rather was gold-plated.
This exact quote acts as our beautiful, undeniable factual trigger. Ritz promised 18-karat gold but delivered a gold-plated chain. This immediately triggers our analysis for material misrepresentation and breach of contract. And hey, because we are dealing with movable goods, a gold chain, we automatically know our applicable law is UCC Article 2.
Now for the fun part. Section 5. Structuring your essay analysis.
For Interrogatory 1, can Ben prevail against Ritz? We are going to lay down a complete, rock-solid foundation. We use a separate IREC structure for this interrogatory, moving totally logically. First, applicable law, noting it's UCC Article 2 for movable goods. Then we establish standing, proving Ben is an intended third-party beneficiary. Next, we run through the formation of the contract between Ann and Ritz. And finally, we analyze the breach itself, focusing on the delivery of that fake gold-plated chain. It is clean, it's logical, and it's fully supported by the facts.
But, as we know, the plot thickens for our next two interrogatories. The prompt states the contract explicitly stated that the contract was not assignable. Yet Ritz went right ahead and assigned the contract and its right to receive payments to Credit Co.
And here is where the magic really happens for the rest of your essay. Interrogatory 2 asks about the validity of the assignment to Credit Co., meaning we have to evaluate the assignable rights and the legal enforceability of that non-assignment clause. Then, Interrogatory 3 asks if Credit Co. can prevail against Ann. To answer that, we evaluate Credit Co.'s standing as an assignee, and crucially, whether Ann has a valid defense for her non-payment. Because think about it, her obligation to pay Credit Co. entirely depends on whether the prior material breach by Ritz giving them fake gold actually excuses her performance.
And this brings us to an absolute superpowered technique, piggybacking. Piggybacking is a structural essay technique where you lay the foundation in the first question and then you just incorporate it by reference in subsequent sections to avoid redundant analysis. You literally do not have time to reanalyze contract formation in question 2 and question 3. You already did it in question 1. Interrogatory 3 directly piggybacks on both prior sections to establish Credit Co's standing and Ann's defense. It's a lifesaver that saves you precious time on the exam.
Now, take a step back and look at how beautifully contrastive this is to where we started. Instead of panicking over that entire massive contracts course outline, our fact anchoring triggered only these 5 highly specific concepts for our essay. UCC Article 2, third-party beneficiary rights, contract formation, material breach and defenses, and assignments. That's it. That is your whole essay, distilled directly from the facts. You can take a deep breath. You can absolutely do this.
So as we wrap up this explainer, I want to leave you with a provocative thought. Think about your current study habits for a second. Are you spending way too much of your precious time trying to memorize massive, overwhelming outlines and simply not enough time practicing how to actually anchor facts to the law? Because I'm telling you, mastering essay reverse engineering and fact anchoring is the real secret to conquering the essay. Thank you so much for joining me, and happy studying.